America, Houston, we have a problem. That's right. I'm back, but only for a moment because we have something very important we need to talk about. Hey, Chipmunk. Ladies and gentlemen, you've been hearing a lot of people say, hey, guys, this is a military rule, military government. Let me turn this instrumental. It's no words today, y'all. We're going to let the instrumental play in the background. I can't tell the difference, so I'm not going to go back and listen to see if you guys can hear the music in the background. It's not important to me right now. We have some things we need to talk about to let you guys know the state of affairs. Many of you think you know what's going on. Many of you think you understand what's going on in the courts. You think you understand what's going on in government. Let's correct your thinking because you were wrong. I'm not going to tell you what I think. I'm going to tell you and show you what I can prove. Okay, the first thing I did the other day was I was responding to a court because I told everybody I'm no longer going in there with the same old lame arguments. They're dealing with mortgage foreclosure and everything. You know that they've been stopping us. They won't let us have a trial. They won't let us go before a jury. They won't let us speak, especially when they know we know what we're talking about. Ever since I started helping all of you, they have been actively blocking my access. But when I started bringing up and hammering them and hitting them in the head with their own laws and with their own words, they have been ignoring everything. They have not responded. And I like Thomas Clark Nelson because Thomas Clark said it better than I could. They have not responded to a single one of my affidavits, a single one of my motions. They have not responded to a single aberrament. But hold on. I don't want any of you to misunderstand why this video is so important that I'm taking the time to do it after I told you I'm not doing any more videos. I'm putting this on both channels. Can't promise you that it's going to stay up there, but I can promise you that they're going to come after me. So I'm going to tell you, download it, go over it, and over it until you understand it. I'm going to explain to you the problem. Okay? I'm going to explain to you the problem. Now, by the way, the music we're playing in the background, if the video gets flat, because he's playing music, sorry, all you got to do is go to YouTube and download 10-hour Motown music mix. It's Creative Commons on YouTube. So if it gets taken down, it gets taken down for one reason only, because of the information. That's just to let you know. Not going to talk about SATCOM in this video. Ladies and gentlemen, SATCOM will start putting videos up on SATCOM that will explain SATCOM and what's... Hey, it's free, y'all! Anyway, SATCOM will be putting videos up on SATCOM that will be explaining SATCOM. Won't be talking about SATCOM anymore on this. The SAT packs, SAT Pack 1, SAT Pack 2, we've already updated the site to let you guys know what's going on with that. Let's get back into what's going on and how we can prove it. Ladies and gentlemen, in 1917, October 6, 1917, this is the Administrative Procedures Act. We're going to talk about the Administrative Procedures Act because it's very important. You see, we're not just going to tell you what's going on, but we're going to give you a remedy. I need you to understand, we are going to give you a remedy, and no other site. Go ahead and check after I do the video. Go ahead and check and see if any other site has provided this as a remedy, especially the way we're going to provide it. And we're going to prove to you that it is 100% legal, lawful, recognized by all branches of government. And the unique thing about it, you guys didn't find out about it because it was done privately originally. Now, I don't prescribe to private and what do you call that? Private and public law, private and public side. There is no private and public side. So all these people who keep saying you got to go in on a private, that is a bunch of crap. Okay, Bandini. I have somebody calling me, and I am not going to be answering that call because I'm doing the video and I'm not going to let anybody interrupt me because this is necessary. So the first thing we have to do is we have to do some research. October 6, 1917. October 6, 1917, and then we're going to put that nice little code, Act. Now, many of you know that October 6, 1917 Act has been codified as 12 U.S.C. 95. Okay, many of you know that. Okay, but the October 6, 1917 Act is the Trading with the Enemies Act of 1917, United States federal law that restricts trade with countries hostile to the United States. The law gives the president the power to oversee and restrict any and all trade between the United States and its enemies in times of war. The reason why they say that you have been declared an enemy of the United States because we're under military rule. Now, I'm not just saying this, I'm going to prove it. I'm not just going to talk about it because it is redundant for us to just talk, because that's what people normally do. They just talk. They don't prove anything. But literally, all coming together this morning. So we are telling you where it's getting started. Now remember, this is a military act. This is not a so-called civil law. This is a military act. It gives the president the authority under his military capacity as commander-in-chief of the United States Armed Forces to do certain things. Because remember, Congress regulated, pay attention, Congress regulates commerce, not the president. However, during an emergency, during a time of war, the president has the power to oversee and restrict or regulate trade. How do you know that? You can't prove that. And that's what some people would say. But then that's where you got to go read the act. We're not concerned about this act. What we are concerned about is Presidential Proclamation 2039. Let's go ahead and read that to let you actually see. So we got PRES, Presidential Proclamation. Oh, did I spell it wrong? Oh, I forgot the I in the initial. I apologize, y'all, but we got to keep going. I thought 2039 would show up, but it didn't. We're not going to go 2039. We're going to go, did it again. We're going to go Presidential Proclamation 2038. Many of you are unaware of what Presidential Proclamation 2038 is. Okay? Presidential Proclamation 2030. Did it say 20? I put 38. I did click 38. I did not do 28. I don't care nothing about no 28. Okay? Nobody cares about 28. We only care about 38. Okay? So Presidential Proclamation 20. Look at that. It did 338. Stupid computer. Google is trying to stop me from getting y'all this information. Presidential Proclamation 2038. This is where Franklin Delano Roosevelt became president on March 3rd, 1933. Before the snow could set in Washington, D.C., or one little particle of snow could melt in Washington, D.C. on March 5th, 1933, because he became president on March 3rd. He was, what do you call that? He took the oath of office. So he assumed the office of the presidency on March 3rd, 1933. Okay. Not even 2 days later, the president said to Congress, I am ordering you to convene. Now pay attention. This was an executive order. You need to understand that. The president, pay attention. Now I therefore, and I have not read this one, ladies and gentlemen. Okay, I have not read this. Congress wasn't due to convene until the following 2 months later. Okay, whereas the public interest requires Congress of the United States should be convened in extra at 12 o'clock noon on the 9th day of March, 1933, to receive such communication as may be made by the executive branch. Now I therefore, Franklin D. Roosevelt, President of the United States of America, do hereby proclaim and declare that an extraordinary occasion requires the Congress of the United States to convene in extra session at the Capitol in the city of Washington on the 9th day of March 1933 at 12 o'clock, in which all persons who shall at that time be entitled to act as members thereof are hereby required to take notice. In other words, this is what the president was saying. If you guys don't show up, I will enact and act on my own behalf. Okay? That's Proclamation 2036. Now, that's just the beginning. We're showing you how this all started. Now, originally it started with the October 6, 1917 Act, the Trading with the Enemies Act. That's how it got started. That's where the president received the authority to order Congress to do anything. Now, we got 2038, but no, he followed that up with 2039. Same president, 2039. We've told you about 2039. We got 2038, and I'm tethering. I'm not at a internet spot, so. But, you know, I can only tell you I'm tired. I'm tired of seeing you all suffer. I could keep this information and just provide it to a silent few and let them put the information out there, but many of you won't believe it if you hear it from someone else, because you know they haven't done any research. Okay? They haven't done any research. I would love to read this one, but this is just somebody doing a so-called essay. I'm about to give you an essay, but I'm about to show you the actual wording of the proclamations. I'm about to show you the actual wording of the laws so you can see it for yourself. Then I'm going to share with you how I did my research so that you'll get the same from it. I have gotten caught up, like Usher said, caught up! Anyway, I've gotten caught up on my research, caught up on my lawsuits, caught up on my appeals, and we're going to, again, I'm going to show you how I've gotten caught up, and I'm going to show you how you can get caught up when you're fighting these banks. Had a property taken 5 years ago, had a property taken 10 years ago, I'm going to give you a solution. I promise you it's a lawful solution that the courts recognize, and you don't need a lawyer to do it. Okay? Presidential Proclamation 2039 declaring banking holiday. Okay? Now I want you to pay it. I'm not going to read it to you like I read it to you before. I'm going to read it to you today so you understand what's going on, so I can prove to you what's going on. And then I'm going to show you where Congress actually confirms everything I'm about to tell you. Whereas there has been a heavy and unwarranted withdrawal of gold and currency from our blah, 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 nobody cares. Whereas the continuous and increasing extensive speculation, nobody cares. That's filler. That makes nothing to do with nothing. Whereas the conditions have created hold on, national emergency. Now that's the key word. Hey, tell us what that word says. It don't want to tell us. I clicked on it, but it says no, it ain't gonna tell us.
National emergency.
There you go, national emergency. Can I hear it again? No, you ain't gonna hear it again. Ladies and gentlemen, that's our key phrase. Want you to focus on that because he added that phrase. That's a legal term. National emergency are not two separate words. It's a legal term. You'll see it in a minute. Now, I didn't do this before, but this was where I was headed when I did something. I'll explain that in a second. Now, pay attention. Whereas we don't care about this. We don't care about this because the president is claiming that he has to take appropriate measures to protect the interests of the American people. Okay? We don't care about that either. That's the excuse. That's the premise for which he says he's operating. We need that. But pay attention. Where it is provided in Section 5B of the Act of October 6, 1917, as amended, that the president may investigate, regulate, prohibit. But, ladies and gentlemen, this hasn't been amended. Oh, you didn't know? Hold on. Let me show you something. This is March 6, 1933. The March 9, 1933 act amending that original act hadn't happened yet. So that means that there was an amendment to that act. Well, when did that act get amended? Because pay attention. As amended, that the president may investigate, may regulate. See, the president gets to regulate currency. He gets to regulate the economy. He gets to regulate foreign exchange. But not within, because he's doing this under his military capacity, because this is a military act. So he cannot do it from within. He can only protect against foreign invasion in his military capacity. But he says that he gets its authority from this act, the Trading with the Enemies Act, a military act, that he's operating in a military capacity. Well, that doesn't say military capacity. It's called the Trading with the Enemies Act. It was a military act. You can't prove it was a military act. You see, that's what I'm dealing with. That's the type of ignorance I'm dealing with. So, ladies and gentlemen, let me show you something so that y'all get it. Because a lot of people, National Emergencies Act, do you see that? That's right. This is an act by Congress, and it's called the National Emergencies Act. The president declared a national emergency. Where did the president get the power to declare a national emergency? Why couldn't he petition Congress for Congress to declare a national emergency? See, an act to regulate undeclared war. I declare war. I used to play that game as a kid. Uh-oh. You know what? I can't use the sidebar. I have to do this first. Touchscreen. I have to do this first. That's my finger. And then I have to do this. But this is the full text. National Emergency Act. Okay. Special Committee on National Emergencies and Delegated Emergency Powers. Why are they delegating emergency powers? Congress does not have the right to delegate its power to another branch of government. That's called the Separation of Powers Clause. They don't get to do that, but they did. Now let's get back to this. We're going to come back to that in a second, ladies and gentlemen. But remember, it says the conditions have created a national emergency. Well, the president has the right to protect the country, but from threats from without. Don't worry about the excuse on how he did that. Worry about the fact that he did it under his military capacity. Now look, I took special sections of that act. The Trading with the Enemies Act, not Trading with the Enemies Act, the National Emergencies Act as declared by Congress. I took that and I took the sections that only highlighted national emergencies and what was the other one? Powers, emergency powers. So I took those two key phrases, and that's what I did, a search through the document, and I copied and I pasted it. Okay, so let's go ahead and find out what's going on. With this final report, the Special Committee on National Emergencies and the Delegation or Delegated Emergency Powers, formerly the Special Committee on the Termination of the National Emergency. See, it concludes its 3-year existence. See, they were the Committee on the Termination of National Emergency, but they've never terminated the national emergency. Why? See, what they did now is they just were on what national emergency was and the delegated emergency powers. Here's the problem. Through the October 6, 1917 Act, Congress gave the president certain authorities, certain delegated powers. Okay, so let's find out what this committee was designed to do. The Special Committee on National Emergency and Delegated Emergency Powers ends its work with an emphatic plea that the National Emergencies Act, House Resolution 3884, be passed as soon as possible. The legislation, which represents a culmination of 3 years of work by the committee, will both terminate, special powers possessed by the president, as a result, the executive branch, military, as a result, existing states of national emergency, and establish procedural guidelines for handling future emergencies with the provisions for regular congressional review. The bill should end the disarray that has characterized emergency law and procedures in the United States. You know, this legislation is long overdue because the majority of Americans live today, in this current day, under emergency rules. Since 1933, these protections and procedures that were provided by the Constitution have been to varying degrees abridged. But hold on, wait a minute. That makes it unconstitutional. Hold on, watch this. I just put in Congress shall make no law. Hold on. The First Amendment to the United States of America Constitution. Congress shall make no law, pay attention, abridging the freedom of speech, press, right to assemble, and your right to petition the government for redress of grievance. They can make no law that abridges your rights. But hold on. Did we not just read that as a result of the existing national emergencies, that they have abridged your rights? See, that they have been abridged by executive directives whose legality rests on the continued existence of presidentially proclaimed states of emergency. Presidential Proclamation 2039, 2038, 2036. 2039, 2038, and 2040. So this was an illegal act. But hold on, ladies and gentlemen, you all are saying, but we knew that. Yeah, but Congress is saying it right here. Congress is saying that it violated the Constitution. See, to varying degrees have been abridged by executive directives. So, see, constitutional procedures and protections. So the Constitution can't protect you anymore because those protections have been, to varying degrees, abridged. But hold on, I know, I'm using the word abridged, and many of you guys don't even understand the word abridged. I know, mama know. Okay, so let's do abridged. All right, give me my definition. Abridged. Hold on. Give y'all Miriam. Do y'all see Miriam? Okay. Past tense, abridged. Past participle, abridged. Shorten a book, movie, speech, or text without losing the sense. No, that's not the bridge that we are referring to. We're referring to this one that highlights law to curtail rights and privileges. Even the right to free speech can be abridged. No, it cannot be. You see, there can be no law against your freedom of speech. And it doesn't matter how the courts interpret it. The law was specific. Every word chosen by the so-called founders were chosen specifically for a reason. They cannot abridge your rights. When you hear someone say that they can be abridged, when you hear the court speaking, saying that they have agreed that this can be this and that could be that, please understand they're doing so in a different capacity. So let's explain to you. There are a couple of things that we need to explain so that you get it, so that you understand what's going on. So we're going to give you the story. But we're going to give you the story and we're going to prove what we need to prove with our story. So let's go back to the time. Woodrow Wilson, President of the United States at the end of World War I. Before the war is even over, because World War I ended in 1918. It lasted from 1914 to 1918. In the end of World War I, and please understand, World War I, World War II were no coincidences. World War I, World War II were all staged events. Sorry, they need to put fear into people. They need to create chaos. Okay? The reason why they create fear and chaos is because they need to pay attention, have better control. I didn't plan that. That was just sitting there. But then I was getting ready to say control, and I noticed it was right in front of me. It's all about control. Go back, watch The Matrix, look at Neo speaking to the architect. When the architect asked Neo a question, and Neo was asking about the reason for the Matrix, and he spoke about control. It's always been about control. From the very beginning, when somebody encouraged somebody to eat from a tree, it was always about control. The whole issue is about control. Some of you will get it, some of you will be ignorant. Some of you will get it and try to understand it better. Some of you will be ignorant and never try to understand a thing, and you deserve everything you have coming your way because you are the reason. Houston, America, we have a problem. Ignorance is bliss. Thank you, Will Smith and The Sixth Sense. Ignorance is bliss because pay attention so that you get it. As long as the majority of Americans live their lives in ignorance, then their rights will continue to be abridged. They will continue to have no control over their securities. So, ladies and gentlemen, in 1917, Congress enacted the Trading with the Enemies Act, giving the president the authority, because it was foreign exchange, so Congress could regulate authority over foreign currency and how it's accepted in the United States and whether or not it's accepted in the United States to another branch of government. Why? Because they could not enact any laws which abridged the rights of the people, respecting the freedom of speech, freedom of religion, freedom of the press. Okay? They could not enact any laws that would abridge the rights of the people, respecting those things. Sorry, I was looking for it, but I think we've already clicked off of it, so I apologize. The First Amendment says Congress shall make no law which abridges your rights, the people of the United States of America. For the preamble, we the people of the United States, in order to perform a more perfect union. Okay, it did not apply to foreigners. So Congress could regulate foreign exchange and give that right to do so to another branch of government. So there is no violation of separation of powers there. Don't worry about it. There are a lot of people that I talk to who claim to be knowledgeable about law and know nothing about law. There are a lot of videos I watch of people who claim to understand the law and know nothing about law. Ladies and gentlemen, I don't claim to know the law. I don't claim to be an expert of the law, but I do claim to know principle. I do claim to know foundational principles of law because I know where law came from. So once you understand the origin of law, the foundation, then you know that every building that is built on a foundation must apply the same principles associated with the foundation of buildings. So every law that is created on this planet must follow the foundational principles of law. You don't believe me? Go and do your research. So when the October 6, 1917 Trading with the Enemies Act was enacted, regulating currency. Later, I believe it was 1920, that it was amended again, and they added another provision to it. During the Great Depression that was caused, they had to come up with an excuse. Now, Congress could have simply just enacted a new law, but then there would have been a lot of backlash, because remember, there was a lot of problems in society at that time. The country was in disarray. Roosevelt had just been put in office. The people had literally not been happy or satisfied. So they couldn't just create something new. So what did they do? Well, Roosevelt, when he came in office, it was all a plan. That's why he already had the proclamations and everything written up. Even though they were a page, these weren't just no simple pages. Go back and look at the proclamations of Franklin Roosevelt and notice how detailed they are. Notice how succinct it is. Notice how he includes where he gets his authority from. He says he's doing it to protect the interests of the people. He says this as a result of foreign banks. Okay, because most of the banks were foreign. They weren't here in the United States. They weren't founded here in the United States. Most of them were foreign banks. So he's saying, I'm about to regulate you, mother. Okay, that's what he's saying. Whereas provided in 716 of the Act, wherefore whosoever shall, will violate any other provisions of this act shall be punished. Okay, and now he issues another order suspending, because national emergency, that is the catchphrase. Now he's regulating currency, even though the Constitution says that only Congress could regulate currency. But during a national emergency, guess what the president just did? It was a national emergency. So he's saying that Congress, when they enacted the October 6, 1917 Act, could then grant this authority to suspend the Constitution in a time of war. Ladies and gentlemen, sorry, you go and look at that junk about during a time of war. That was never the intent of the Constitution. Because if you suspend the Constitution during a time of war, you've just abridged the rights of the people, for which there could be no law created doing that. The First Amendment is very specific, very clear. When it says what it says, hold on, we're going to go there. Congress shall make no law. It is because of this statement right here that we have Congress being the lawmakers, because that is the implication, is only Congress can make law. Okay? Congress cannot make a law abridging or prohibiting the rights of the people. See, that's why you have religious freedom. That's why you have freedom of speech. That's why you have your right to exercise your rights. See, the free exercise thereof. You have the right to exercise your rights. Okay, which is why you'll hear someone like me say, don't just reserve your rights, don't just preserve your rights, exercise your rights. Now, but they suspended the Constitution, you said. You're absolutely right, but I want you to understand, I didn't say they suspended the Constitution. Let me finish giving you that history, and you'll see how they said they suspended the Constitution. Because they came up with an act that says that habeas corpus can only be suspended during times of war. So habeas corpus is a constitutional right. It is a common law right. So if that right can be suspended, that means the other rights can be suspended. But no, that came after the Bill of Rights. The Bill of Rights is the foundation. You cannot erode the Bill of Rights, because you erode the Bill of Rights, you erode the rest of the Constitution. What happens is this president and Congress both enacted this into law. The Trading with the Enemies Act was signed by the president, so you have 2/3 of the government. Okay? The Supreme Court has no say-so. The only way the Supreme Court can have a say-so if somebody challenges the October 6, 1917 Act is unconstitutional. Hold on. We're not there yet. But this is why the Supreme Court has never had it decided. The Supreme Court operates in two capacities. One, judicial. The other, administrative. So most of the decisions, most of the cases that come before the Supreme Court are administrative. So there must be a constitutional challenge before the Supreme Court saying that these items are unconstitutional, and you bring up the unconstitutionalism of the acts based on the information that was just provided to you. That Congress cannot delegate its authority to any other branch of government because it's a violation of the Separation of Powers Clause, and it doesn't matter what Congress or the Supreme Court says. It matters what the original intent of Congress was. It has nothing to do with their interpretation, because the Supreme Court nor the presidential branch of government, nor any other administrative branch of government may sit up here and interpret law. They must follow the principles of statutory interpretation. What was the original intent of Congress? They cannot go contrary to the original intent of Congress. So in 1933, when Roosevelt became president, he said, hey guys, I'm taking over. And so he ordered Congress to convene. The president does not have the authority to order Congress to convene. But
Yeah, they do, because they did it before, and they set a precedent when they had the other presidents ordering Congress to convene.
you're absolutely right. A precedent had been set. So now the president was following precedent. One is spelled with an I, the other one's spelled with an E. Precedent and president. One means a person, the other one means an event. Okay? Sorry. Just have to explain that to some people because they would not get why I'm saying president and precedent and why I'm playing on the word. All right. So he orders the emergency session of Congress. Now, I want all of you to go back and pay attention to what Tiberius Caesar and other kings have done in the past. When Tiberius Caesar ordered the Senate to come together and convene, when other governments have ordered their Congress to convene and they set the whole building on fire, when Tiberius Caesar ordered the Senate of Rome to convene and he had his Praetorian Guard surround the building, making them afraid for their lives so that they can enact certain laws. Well, the very same thing was going on here. The president was saying, I'm acting under my military authority by the powers you idiots gave me from the act of October 6, 1917. And if you go against what I am suggesting, then I will make sure that none of you get to convene anything. Now, they did this based on what happened after the Civil War. The Civil War, I did not know that the so-called, you had the Confederacy against the Union Army. The Union Army occupied the states of the Confederacy when they conceded in the war. I did not know they were in occupation. I did not know that because I didn't do the research on that because it wasn't important to me. I didn't care about the Civil War.
Well, you gained your right to this.
Shut up. I don't give up about no Civil War. I don't give about no civil rights. I don't care about no marches. I don't care about no protesting. None of that has anything to do with me. I wasn't there, wasn't a part of it, and I did not benefit a single bit from nobody marching up on no Plymouth Rock.
He said Plymouth Rock, like the marching happened.
Anyway, ladies and gentlemen, none of that stuff matters because we're not under any of that. The Civil Rights March happened after March 9, 1933, which means that that was all for show, that nobody was gaining a single right, but you don't understand. You don't get it. So we're going to keep explaining it to you until you understand it, till you get it. When the president assumed power, Congress then supported the president's power by passing the March 9, 1933 Act. Now remember, ladies and gentlemen, hold on. We're going to go here because remember, he ordered Congress to convene on March 9, 1933. So sorry, I messed up, y'all. I got to put my comma. Oh, there it is right there. March 9, 1933 Act. Now, the reason why we're doing March 9, 1933, the act is because it's important. Now, we're going to do something else so y'all get it. Watch this. Hold on. Come on now. Uh-oh. Sorry. I wasn't trying to do that. Okay, this is what I'm trying to do. And the Emergency Banking Act of March 9, 1933. No, we're going to go with text. T-E-X-T. Not even going to put full text because don't need to. It automatically assumes we want the full text. Oh, by the way, have you guys been hearing in the news how Google has been changing its algorithm?
But I've been telling y'all for all this time that Google keeps changing its algorithm. That's why we can't find certain things when we're trying to look for it.
Exactly. I want the act. I don't want the PDF because I already have it. And this thing says history. I don't care about the history of the Federal Reserve. I just want the act. Let's do this right here. Congressional Record, March 9, 1933. This is actually going to be the Congressional Act of 1933. Okay? Now, District of Columbia on Thursday, the 9th day of March, 1933, and was adjourned. The issue was the presidential proclamation. Ladies and gentlemen, I'm going to download this because I'm interested in it. But what I'm going to suggest to all of you, and this is my suggestion, is that you take a look at the act and ask yourself, how is it possible for Congress to enact an act the same day it's introduced, and they met at 12 in the afternoon, and it was passed within hours? Now, I want you to take a look at this act. Take a look at all of the writing. Take a look, and I need you to tell me how in the world could Congress had sat there within those less than 12 hours and put together this whole act. Okay? How is it possible? Go ahead and look at all the other things that Congress did. Now remember, the president was calling an emergency session, so from the 5th, when he first called the emergency session, to the 9th, we have 4 days. And remember, we don't have a full day on the 5th because they received it on the 5th. So we have 4.5 days, or 3.5 days. So how in the world, oh my God, how in the world could Congress have come together and put together this act? Because we know that those are members of Congress. How in the world are they going to all come to an agreement, put together this act, and put it before a vote all in the same day? Now remember, this is the only thing they were considering the whole day, but pay attention. They had all of these sections. They had to focus on the words, and we know that that's what they do. They focus on words, okay? This is the act. These are all of the words that they put together, the percentages and everything, and they did this all within 1 day. Oh, whoa, look at that. They met at 12 p.m. in the afternoon, and less than 8 hours later, the act was approved and signed by all the congressional members. Amazing, ain't it? Impossible. All right, let's get back to making sure you guys understand that the act is a military act. Now, again, I am not saying this. I did not say that the March 9, 1933 was a military act. I'm going to let someone else say it to you. Now, this is the first thing you need to pay attention to. This is from the actual records of Congress. Passage of the National Emergencies Act will be a major step towards restoring Congress to its proper legislative role. So, wait a minute. Do you mean Congress does not sit in a legislative role? No, because the president has that role.
No, you can't prove that.
The legislation represents significant progress in checking the growth of executive power and returning the United States to normal peacetime processes. The measure is vital in ensuring the United States travels a road marked by legislative oversight and carefully constructed legal safeguards. Of course, I didn't say that. They said it. The legislation represents a significant progress in checking the growth of executive administrative powers and returning the United States to normal peacetime. We have been in a state of declared war or emergency. That's why the October 6, 1917 Act is called the War Powers Act. We didn't do that. They did that. Now, hold on now. This is not the only point where they talk about the fact that Congress is not sitting in its proper legislative role, that the president does the legislation. Hold on. We're going to show y'all. We highlighted that for y'all benefit. Y'all. That's right. I keep saying y'all. Let's pay attention to this. And when you get a chance, ladies and gentlemen, because I have not looked up this code, I have not looked up this code. I have not looked up this code. Now, this code right here is the Administrative Procedures Act. This code is the Administrative Procedures Act. Title 5 is the Administrative Procedures Act. This right here, I believe this is 10, not S. Okay, but anyway, under 10 USC 333, the president can use the militia or armed forces to suppress conspiracies.
Oh my God, he's coming after me. Oh no, it must be a conspiracy. You're talking about a conspiracy. No wonder they're going after Alex Jones.
I'm sorry, apologize. And if it is likely that any part of the people in a state will be deprived of some constitutional right, hold on. If it is likely that any of the people in any part of the state can be deprived of constitutional right and the state itself refuses to act, then under this statute, the president conceivably could circumvent Article 4, Section 4 of the Constitution even before the state legislature and state executives could act and could request foreign troops. It says under 10 USC 1383, the president has the authority to declare any part of or all of the United States military zones. This is where you get those people saying non-military zone. Okay? That's where it's coming from. The president has the authority under the United States Postal Service, an administrative agency. The president has the authority to declare any part or all of the United States. No, he doesn't. A military zone. Why can't he do this? Because the law, the Constitution says that the military is only there to protect against foreign invasion. Okay? And because of the, pay attention, sovereignty of the state, the president cannot invade any state in America. Yeah, I know, insurrection and rebellion. Okay? However, here's the problem. That can only be declared by Congress. Only by Congress. Sorry, this is me having my chiming. Every time that chimes, my phone chimes. See? That's another one. So now I got to close it out again. Anyway, let's get back to the legislature. It says, people in such zones can be jailed for a year for violating any executive order of the president. Ladies and gentlemen, hold on. That's a lie. The president's executive orders have no bearing over the people. The president cannot make an executive order that encompasses the people. He does not have the authority. Only Congress can make laws that apply to the people. Executive orders can only apply to the military or the administrative branch of government. Hold on, we're going to get there. Would these arrests be reviewable in court? It is not clear. Judicial review of agency action is guaranteed in Section 5702, but Section 5701 excludes actions taken under declaration of martial law. Now, aren't they talking about emergency rule? So are you telling me that 2039 is a declaration of martial law? Of course it is, because he said he was doing it under the authority of the Trading with the Enemy Act. It was a declaration of martial law. Go ahead. He declared a national emergency. This is the National Emergency Declaration Committee to determine whether or not blah, blah, blah. See, under 47 U.S.C. 606, the president can amend as he sees fit the rules and regulations of Federal Communications Commission, and in particular can cause the closing of any federal facility or station for wire communications. If the president finds the nation threatened by attack, he could, under 44 U.S.C. 1505, cease to publish his regulations in a Federal Register. See, when it's published in a Federal Register, it becomes law. If he determines that it is impracticable, this could be could open the way to promulgating secret laws. Has this already happened, ladies and gentlemen? Of course it has. That's why they're talking about it. But then you don't get to find out about those secret laws. There could never be any secret laws because the president could never enact a law. President does not have the authority. No branch of government can enact a law that abridges the rights of the people. Ladies and gentlemen, all I did was went through that law and I just highlighted the sections that spoke about national emergency, emergency rule. Okay, emergency powers. That's what I did. And then after doing that, I pulled up all of this. Out of that, those hundreds of, well, it's not hundreds of pages, but there are a lot of pages to that act. And so what I did is I decided to focus on one thing. Okay, hold on. I also did confer because, see, notice this. Consider what administrative or legislative action might be necessary or desirable as a result of terminating such national emergency, including consideration of the desirability and consequence of terminating special legislative powers that were conferred to the president and other officers, boards, commissions as a result of the president proclaiming a national emergency. Ladies and gentlemen, Congress do not have the authority to confer its legislative powers to any other branch of government. It is a separation of powers clause. Okay? But nobody's ever challenged it, and the Supreme Court has never heard a case where somebody was challenging these acts. You must understand the Supreme Court cannot act on its own. It does not have the authority. The Constitution does not grant the Supreme Court the authority to act on its own, to hear a law and declare the law unconstitutional. Every time the Supreme Court has declared a law unconstitutional, it has been because the people has brought that to its attention, or the Attorney General has brought it to its attention. Because other than that, once the president signs off on it, it becomes law. So that's where we get to this one. Hold on. Yeah, we're going to go over an hour because I already know it. We're going to go to, come on. Sorry, it's delayed. So we can go NH. Oh, okay, let's get rid of that. NH. And now we're going to do HR. HR 1778. 778. Ladies and gentlemen, we just giving you the information on how we know we're in military rule because Congress have already said it. Okay. I did an HR. Let's get rid of the HR because it did it again. I want New Hampshire. And let's do it this way. TRAVEL. Okay, bill text the law that was passed in New Hampshire. Okay. Give me a second. We're going to go there because we need to let you see New Hampshire tell you what type of a position we're in. Then we're going to tell you what has been done for the people who have signed up. We will tell you that in a second. Let's make sure you guys understand. This is a bill that relates to the right to travel. This was not written by no sovereign citizen. Well, technically it was written by a sovereign state. Okay? Statement of purpose. The general court finds. What's the general court? All three branches of government. The court, you're going to find a chief justice. Okay, so you got the court, you got the legislature, and you got the governor who signed the law into law. Who signed the bill? I'm just a bill. Yes, I'm only a bill. And I finally got the Capitol Hill. Well, now I'm... Okay, anyway, I made it to Capitol Hill. The bill, y'all remember ABC Rock? Come on now. Y'all remember it. Don't play. Don't front. I don't care how much you stand out on the corner trying to act like you hard and everything, trying to act like you gangster. I don't care how many drugs you sold. You knew about ABC Rock. Okay? You knew about I'm just a bill. You knew about conjunction junction. What's your function? You knew about it. So don't front and act like you didn't. Got so many people out here faking the funk. Trying to fake it, trying to make it look like they didn't pay attention to certain things because they think it makes them look weak. You're only as weak as your mind allows you to believe you are. Now let's take a moment and talk about that for a moment. Then we're going to segue back to this law. A lot of you have too much pride. You're steadily trying to prove who you are. Look here, that's ignorance on the largest scale. You don't have to prove anything to anybody about who you are. You only have to prove that to yourselves. Some of you are walking into these courtrooms, walking to these agents, walking to these employees, and you're yelling and spitting and spewing and trying to tell them what you ain't gonna do, what you ain't gonna allow, what they gonna do, what they all about. And let me say this to you, because you're gonna misunderstand me when I tell it to you. But that's stupidity and ignorance. Stop being so ignorantly stupid. Stop telling them everything. Simply, I promise you, I accept your offer, having full immunity, and I do so without recourse. Or I accept your offer with full immunity and without recourse. It's called a conditional acceptance. Everything's said in that one phrase. I accept your offer with full immunity and without recourse. It's right there. You can even do it. I accept your offer under full immunity and without recourse. You can say with or under. Doesn't matter. You don't have to put them together. But I accept your offer with full immunity and without recourse. Then have the conversation, people. You've reserved your rights. You've exercised your rights and you've retained your rights all at the same time. And you protected yourself under immunity, and without recourse means you cannot be held liable if that checking of your words bounces, so to speak. Okay? So what I'm suggesting to all of you, stop trying to prove who you are. That's a sign of weakness. And none of you should be so weak. You don't have to prove to anybody who you are. You just have to prove it to yourself. Now, what I usually tell people, and I'm very serious about this when I tell it to them, I basically say to them, oh, so you want me to introduce myself to you. And as I've told many of you, whenever I've had to introduce myself to people, they have always come back to me and in their own little way begged me to let them be, begged me to leave them alone. So we've always come to a settlement at the end. We got a lot to talk about, so hold on, y'all. It's all gonna start here. So if you want to, take a break right now, pause the video, go get yourself some popcorn, get yourself some Hennessy, get yourself some orange juice, get yourself some gin, get yourself some of that chronic. Then you don't need to be watching my videos because none of my people do that stupid stuff. That's right, I said stupid stuff. All of it is stupid. Because it diminishes your ability to think and focus. And those of you who convince yourself that doing such things allows you to think and focus more, oh, Lord, have mercy. You deserve everything you got coming to you. Ladies and gentlemen, they introduced these drugs into society. They created the so-called drug arena, drug war, drug this, drug that. They did all of that. The prohibition on alcohol was done on purpose. Why? Because they needed to create an industry. That they not create an industry. That they not create a black market. That they not create the so-called little back routes, doors, and back trade. That they not create a mafia as a result. So then they made drugs illegal because remember they used to give people cocaine like it was water. Cocaine, you could get that any place you want. You go to the drugstore and get it and it was over the counter. They added it to Coca-Cola, where the name Coca-Cola comes from. They create industries. Lord have mercy. I just wish some people would recognize. So let's finish giving you the information. And ladies and gentlemen, a lot of you are going to try this. I'm going to tell you to do your research first. Please listen. You need to do your research first. There's not a lot of huge consequences you can run into, but when I make the suggestion of what I'm going to make, then there could be huge consequences, and I'm going to explain what those consequences are. Possibilities, so you're going to have to think about it because they've thought about it. Nothing I'm telling you is anything. They knew this information was going to come out. They just didn't know anybody would put together the pieces the way they're putting together the pieces so that you get to see the pieces so that you would be able to use it. But this information out, they haven't hidden anything from you. Matter of fact, the Supreme Court and Congress has been begging you guys to bring this stuff to the right attention. So we're going to tell you how we think it's possible for you to do it. We're going to give you a legal process that 3 men have already done. Whoo, doggy. And when I heard about it, I'm like, that's impossible. Please, you can't do that. They told me they talked to an attorney, and the attorney told them the same thing. I said, yeah, he's right. You can't do that. Then he said, the attorney came back 3 weeks later, and he took on the case, and he actually got a victory. Wait, hold on, y'all. Because I came back to the person 3 weeks later and told him, man, you guys realize what you did? I don't think you realize what you did. And took off from there. So we're going to talk about that, okay? So I want y'all to be prepared. We're going to talk about that. All right, let's continue because I got a lot of work to do. I'm going to try to get this video out to you guys today because this is the video that's going to get me locked away. I promise. I guarantee you. Because this is the information they don't want you to have. So let's continue. Be it enacted by the Senate and House Representatives in general court convened. That means that everybody was there. The Supreme Court, the governor, and the entire legislature. It says, finds that the authority of the government is limited only to commercial users of the public ways, and that the corporate state employees or corporate government, by their silence, failed to fully inform the sovereign people of the United States that any property has been confirmed in law to be private property, Uniform Commercial Code, defined in the Uniform Commercial Code, Article 9, Section 102 and 109 as household goods and consumer goods. 102 gives you the definition of household goods and consumer goods. Okay? That's how we know. See, 102 says, and shall include an automobile. Duh. 102 gives the definition of consumer goods and household goods. Let's continue. Not for commercial use, or for profit, or for gain. Ladies and gentlemen, you will put this on your license. Okay? You're going to say that your property is defined as household goods, consumer goods, and is not for commercial use or for profit or for gain, that it is private property and it is exempt. Okay, let me pull out my wallet so I can explain it to y'all once again. My wallet simply says all over the place, y'all. UCC 9-102 and the symbol for N 9-109. Exempt. Then the next line says private property. The next line says no trespass. And then I have the codes for private property and I have the code for no trespass. Now the other one says, oh no, I didn't do the other one. Oh, household goods and consumer goods. I didn't need to put household goods and consumer goods because I put UCC 9-109 and 102. So when I put that, I included household goods and consumer goods. When I put private property, I took care of the private property. When I put exempt, and let's do that for you because we need to show you that because you need to see it. Okay, take a look. 109 talks about exemption. It says, and shall be exempt from license and registration required for commercial motor vehicles. You see, the only vehicles on the public highways required for license and registration is commercial vehicles. So the police pull you over, you say, oh no, this is not a commercial vehicle. Just that simple. This automobile is private property. It is exempt from license, registration, or commercial laws. See? Notice of the holder's exemption from the statute that are required for commercial use of the public ways for profit or gain. You go before the judge because some of the officers are going to yell at you. They're going to get stupid. They're going to take you in, and you just tell, sorry, apologize, but my vehicle is not used for commercial use, commercial profit, or commercial gain. It's private property. It's exempt. So, sorry, but I'm going to have to charge you for your violation of due process. You don't have to argue with them. Just let them know I'm going to have to charge you for violation of due process. I'm going to have to impose sanctions upon you. You don't have to tell them how much the sanctions are. Just say, I'm just ordering that sanctions be imposed upon you. Their rules require it. See, when you introduce false and misleading information into the actual court record, when you waste the court's time, when you waste the public's time, you can be sanctioned. Sorry, it's got exemption one more time. No person except those expressly exempt under code or other provisions of this title shall drive any motor vehicle upon the way of any state for commercial purposes unless such person has a valid driver's license as required by provisions of this chapter. You see, that's the way it was worded before in every other state, but you didn't know that a driver's license is only required for a person. You are exempt, but you don't know that. You keep hearing people talk about exemption, and they've been explaining it to you wrong. See? That states the holder is exempt from registration of his or her private conveyance under the commercial code. You are exempt. You need to go to the DMV, and I am telling you this. Go to the DMV, say, I am exempt. My automobile is not used for commercial purposes. I am exempt from registration fees and or license. And I need you to correct the record. Some of you are going to be told, oh, we don't know what you're talking about. That's one of them sovereign arguments. Really? So you're making an executive decision? All right, then I need to appeal. What's your process for appealing your decision? What? Well, no. You just made a final determination. You made a final decision. So what's your appeal process? And people follow the appeal process. Don't argue with them. Why are you guys arguing with these idiots? You look like an idiot when you're arguing. You just made a determination. This was a hearing. You just came to a final conclusion, a final decision. What? You didn't know that was a hearing? We did this already. We done talked to you guys. When you go to the DMV and you meet with that person at the window, okay, hold on. Uh-oh, I did it wrong. I have to go here. I don't want bailment bond definition. I mean, I could look at my own files and folders, and I'll do that because I got to show it to you. Okay. Look at that. Scripted did. It's got it up on script did. There you go. See, we can find the bailment bond. The bailment bond is at satcom911.com. Whoo, doggy. Bailment bond. Satcom911.com. I wonder, where have I heard of that website before? Satcom911.com. Uh-oh. Under construction. It ain't under no construction. That's because we went straight to the location of the file. Okay? No, we're not going to download it. Downloading it will be stupid because I already have it. So what we're going to do is we're going to go Documents, Documente, and we're going to go BAILMENT. Then we're going to go Bond, BOND. It don't want to go. Hold on now. Sometimes it does that. I don't know why it does that. I guess because I have this bootleg version of Windows. So let's do Come on now. That's what I'm looking for. Now that's what I'm talking about. Anyway. And all of you idiots who brought those idiots into the hood and started using ebonics around them so that they can go, now that's what I'm talking about. Give me 5. Y'all don't know what y'all did. Stop sharing the secrets. You know what's wrong with y'all? Got people talking about give me high five and trying to high five people. Would you tell these people we don't do the high five thing anymore? Would y'all, somebody, would you please tell them we don't do the high five thing anymore? That we don't go, now that's what I'm talking about anymore? That we don't go, what's up? We don't go, sup? We don't do that no more? Would somebody please educate these people? Because they don't realize how awkwardly ignorant they look when they're doing that, and I want to save them from the awkwardly ignorant looking that they are demonstrating by their awkwardly looking ignorance. Okay? Look, I'm trying to open it, but I guess I'm doing too many things. Got too much open on my computer because it's not opening. But I just want to show you that law. Hold on. Forget that. I have some other place I can show it since Microsoft Word ain't opening, and it definitely ain't opening. So we're going to go to PDF Exchange. Now, you know, I am very glad to have introduced PDF Exchange Editor to all of you. The company, if you don't have a copy of PDF Exchange Editor, just type in PDF Exchange Editor online and just go to PDF Exchange Editor, okay, to their website. I assure you, once you've used the product, you'll be all right. You'll be like, man, where's this been all my life? Okay. Now, we're going to go here. Belmont Bond is finally pulled up. Now, this was a long time ago. 2012, this stuff was done. All right, but we're going to go to the Red Riding. Little Red Riding Hood. That's right, Red Riding Hood. All right. Due process requires at a minimum that an individual be given a meaningful opportunity to be heard. Okay, when you go to the DMV, you're being given an opportunity to be heard. You are having a, pay attention. I want you to pay attention to the word, a hearing. Okay? Hold on. Is that what the Supreme Court is saying? Of course that's what they're saying. It says that the hearing required by due process is subject to waiver. You can leave. They're not forcing you to be there. So you can waive your right to be there. Okay? Is not fixed in form. Well, you don't have to be in a formal setting. It doesn't have to be in a room with a bench with a person in a black robe. You just need to be before a hearing officer, someone who has the authority to act on behalf of the agency. Does not affect the root requirement that an individual be given an opportunity for a hearing. You have a right to speak before he or she is deprived of any significant property interests. So you go to the DMV to register your automobile, but you don't do it as exempt. You don't even put exempt on the application. You don't ask them for where's the exemption application. Because my automobile is not for commercial use, so I need the non-commercial use application for registration. They tell you, well, we don't have one. Well, you just went to a hearing. Well, say, I need to appeal your decision. Because that hearing officer just made a determination, the same as a judge is a hearing officer. Are you starting to get it? When you go before a judge, you're going before a hearing officer. You're having a hearing. Look. That is the reason why this case, let's go back up here so that you guys can see this case. This case was a California state case. Okay? This case started in pay attention, the regular state court. This is the 3rd district in California. Sorry, I got somebody calling me and I'm gonna have to call them back for certainty. Okay. But anyway, ladies and gentlemen, you're being given your hearing. This started out in a state court. and made it all the way to the Supreme Court. This is the Supreme Court of the United States. Why? Because this had everything to do with due process and an individual's due process rights. And when, in this case, the individual did not receive the right to a hearing, this went before the Supreme Court. That's why it says at a minimum, you must be given an opportunity to be heard, because that's your First Amendment right. You have a First Amendment right to be heard. You have a Fifth Amendment right to due process. Okay? Pay attention. In the latter case, because they continue to hear this, Central Hoover Trust Company, the United States Supreme Court, we said that the right to be heard has little reality or worth unless you are informed that a matter is pending and can choose for yourself. When you receive the notice, the administrative process, they send you a letter. That's your hearing, because you have a right to respond. And they give you an address. So that's the hearing place, is through the mail. They give you the address. That's where the hearing is taking place. You have the right to respond. You respond, they respond, that's your hearing. Okay. Whether to appear or default, acquiesce or contest, or forfeit, or concede. Okay? Again, a case that started in a lower state court and went all the way to the Supreme Court. Now hold on, so that y'all can see it. Next point. There are other decisions that affect that one may be deprived of property by summary administrative action taken before hearing, when such action is essential to protect the vital government interests. So it says that you can have your junk taken from you before you get a hearing, such as when they take your children from you until they give you a hearing. Okay? Just thought we'd explain it to you. This is why most of you are not getting it. So what's your solution now that we're under martial law, under executive order by the president? What's your solution to all of this, to them having these hearings, having these, saying that your property is commercial use and they can regulate it? What is your solution? What is it that you get to do? It's real simple. Let's talk about it for once. Let's see. It's not these. These are, yeah, this is it. The Administrative Procedures Act. This was enacted in 1946. I want you all to pay attention to what's said here in the Administrative Procedures Act. And yes, I know a lot of you miss me doing videos because this is where you would get a lot of information like this. But I'm not doing videos anymore. I'm only taking the time to give you this because, one, we can prove that we're under military rule. Two, we can prove that it's all administrative. Government is strictly administrative. That's why when you go and you look at everybody who's incarcerated, all of the prisons sign a contract with the DOJ. The DOJ signs a contract with the Department of Defense. That's why the Federal Bureau of Prisons is located on a federal defense base for the United States military in Grand Prairie, Texas. Okay, it is military rule. But remember, the military cannot put its hands on American citizens. It can only act against those who are trying to cause damage to the United States, which is where the Trading with the Enemies Act, which is what they have done. They have declared everybody whom they incarcerate, everybody whom they put in their military zones as enemies of the state. There you go, just to let you know. All right. The Administrative Procedures Act, United States law enacted in 1946, that stipulates the ways in which federal agencies may make or enforce regulations. The APA, now remember, federal agencies. Interesting, huh? Now, you read the act and it says it doesn't apply to the United States courts or the United States Congress. That's a lie. The Administrative Procedures Act applies to them in their administrative capacities when they're operating in their corporate capacities, because in their corporate capacities, they're registered under the main administrative agency, the Secretary of State for the United States. So it does apply to them in their administrative capacity. When they're acting in commercial business, when they're doing commercial business, the Clearfield Doctrine falls in and comes into play. The APA was a product of concerns about the rapid increase in a number of powerful federal agencies in the first half of the 20th century, particularly during the administration of President Franklin D. Roosevelt, who created a number of agencies to implement his New Deal, social and economic programs. Ladies and gentlemen, They're letting you know here that the Administrative Procedures Act was done to try to curtail what the president was doing, the executive branch, because some of them were going buck wild. Agencies are extensions of the executive branch. Hold on. I know. Agencies, such as all of those who engage in commercial business, such as the branches of government that are registered with EIN numbers. They're registered with the Secretary of State. They're extensions of the executive branch or administrative branch of government that have the ability to make, implement, and enforce rules and regulations. That's right, they're regulating, because the president has the right to regulate under the Trading with the Enemies Act. Because they are unelected and arguably combine executive, legislative, and judicial functions. See, they are unelected and arguably combine executive, legislative, and judicial functions. Agencies have been criticized as undermining the separation of powers between the three branches of government. This is not my site. I didn't even know the site said that. I just found this site the other day. But I just want you to know the argument is none of the people have argued that what the president did, the foundation people, the October 6, 1917 and the March 9, 1933 Act is unconstitutional because Congress did not have the authority to delegate any of its authority to any other branch of government. It is a prohibition against the separations and limitations of government. The Constitution placed limitations on government. You can't suspend those limitations. It could not be a power grab. It was a pretty good idea back in the day when you had people who didn't know the law, who didn't understand the law. Pretty good idea for them to figure out a way to do this, but they can't do this. So we'll tell you what we're doing. We have a lawsuit here in the state of California where we brought the lawsuit under QTAM, and we've raised these issues in our QTAM lawsuit. The Attorney General has decided that he does not want to participate in the lawsuit. The state, we filed it as a common law lawsuit because, you know, they said they suspended common law. There is no provision in law for them to suspend the common law. There is not one single provision in law where common law can be suspended in the United States. But they said they suspended common law, but yet California is a common law state. So we brought our lawsuit under common law under the 7th Amendment. Because we're saying you can't suspend the Constitution, you don't have the authority to suspend the Constitution. That those acts enacted by Congress and every other act enacted by Congress associated with the Trading with the Enemies Act are unconstitutional because they were acted under the false pretenses of a valid act, a valid law. Well, a party to the lawsuit who's not been served has come into the lawsuit requesting the case be dismissed. We're telling the court, you can't dismiss this case. We're challenging the statute. We're challenging the act. You can't say we failed to state a claim. Of course we can challenge the statute. Of course we can challenge the act, which means we have a right. So go ahead, because when you do a QTAM lawsuit, ladies and gentlemen, you get to appeal directly to the Supreme Court of the United States. There is no, you got to go through the appeals court. There is no, you got to petition for certiorari. Certiorari. There is no so-called. You go straight to the Supreme Court. If you're wondering how to get to the Supreme Court without going through the appeals court and all that stuff, QTAM lawsuit, because your appeal goes straight to the Supreme Court. But if you're going to do a QTAM lawsuit and become a relator, or a, what do you call that, a private attorney general, because that's the proper way to be recognized as a private attorney general. You don't become a private attorney general just because you interpreted what Congress said. That makes you a private attorney general. You become a private attorney general when you get the United States government and you represent the United States government. You give the attorney general an opportunity to respond and to act as if he wants to represent the United States. And when the attorney general says we don't want to do that, then you become the relator. Relator, not realtor. Okay? Oh, I like relating things. Anyway, let's get back to your remedy, ladies and gentlemen. The Administrative Procedures Act is your baby, is your boy, is your little darling. Hey, Donna! Okay, I'm waiting for my folder to pull up. I'm looking for that folder. Let's minimize some things. We got a lot of things open. Minimize. Oh, we don't have a lot of things open. Well, they're all down here open. But come on now, open up. Open, open, open. Macy's. Open, open, open. We're going to show you a private law. Now, while that's waiting to open, let me explain to you what happened. There were a total... Look, the dinosaur. It's a dinosaur. Do you see? The back, the legs, the belly, the legs, and the mouth dipping into something. It's a dinosaur. That is so nice. Other people probably wouldn't even notice that that thing is in the shape of a dinosaur. It's a natural thing. Look how long that took to open. That don't make no sense, y'all. That don't make no god darn sense. Come on now. Well, these three gentlemen, they were in jail at the time. One of them, let's call him Mr. Sparky. Okay. Mr. Sparky, his name was going to appear in a document. It's public record. Well, he had done a little bit of research. He had a little bit of dinero, so he could pay for his own attorney. And Mr. Sparky, he was out on bail, and he decided to do some research. And so he went over some research material, even watched a couple of somebody's videos, and he put together this, well, I can only call it a unique document. Okay? And his document was done so uniquely that the courts did what they normally do. They ignored it. He had 500 points of averments. The document was over 60 pages long. But he introduced a clause in the document that got their attention. I don't know what's going on here, y'all. Why it's going so slow, because it shouldn't be going so slow. That don't make no sense. So we just gonna go to the document section. I can go to the document section or the other section, but we're gonna do law, L-A-W. And let's, come on, L-A-W. Not that law. No, that's too, those are not the laws I'm looking for. That's not the one I'm looking for, Chief. So he cold dashed and ran around a block. Cop radio said to another lady cop, "I need bullets, hurry up, run." The dope fiend barked back a spanking shotgun. Sirens sounded, he seemed astounded, and before long the little boy got surrounded. He dropped the gun and so went the glory, and this is the way I have to end the story. Why did he end the story that way? Because it was a bedtime story? Oh, okay, I guess that makes sense. Oh, I'm sorry, that's Children's Story by Slick Rick. I just figured I'd pass the time while looking for that law, but I don't see that law. I don't want the law merchants. I don't want the laws you did not know exist. I want public law. No, this is a private law, so I don't want public law. I want the private law. Uh-oh. Looks like I won't be able to find it. I had it the other day. Huh. This doesn't make any sense. No. Huh. That's a shame. I'm gonna do S.112. Let's see if that will do. And if that doesn't work, because I need to show you the law, because I'm gonna show you how well it was. These gentlemen, when they put together that paperwork, and he brought in two of his friends who were there at the same facility, and he helped them understand the process. It's a simple process, ladies and gentlemen. What he did is he did the administrative process, and he wrote something to the court, and the court failed to respond. He gave the court an opportunity to cure their default because he only gave them a certain amount of days to respond. They did not cure their default. See, I give the courts 14 calendar days because I don't have time to be playing those stupid games with you. So I'm only going to give you 14 calendar days. I think this is the law I'm looking for. This is the one I'm looking for, Chief. Okay, so that's the one I'm looking for. And yeah, because that's number 1. Oh, you're number 1. You better believe I'm number 1. Well, you don't have to believe it. Well, you do have to believe it because it's a fact, and facts have to be believable. Okay, here is the public law, ladies and gentlemen. So this is the public law. I mean, private law. This is a private law. Private law. 114th Congress, second session, Senate 112. A private law introduced by the Senate of the United States. In the United States Senate, November 5th, 2016. Now, I want you to pay attention. The main, and this is Mr. Sparks, but his last name is Stark, okay? Bradley Christopher Stark. Chris introduced this. Sean Michael Rideout, I don't know Sean. And certain named beneficiaries, okay? For the relief of this. Now, we're not asking you guys to go to Congress to get a private law. We don't want you to focus on that. We don't want you to focus on that, so don't do that, ladies and gentlemen. I want you to stay with me because I know this video is going to be long, but there's a process, so we want you to recognize the process. This is the United States Senate and House of Representatives of the United States of America in Congress assembled. They give definitions. This law was actually passed, ladies and gentlemen. They tell you that it's a stipulation and settlement agreement. See that? Addendum to the agreement. Addendum to the agreement. And then it says between Bradley Christopher Stark and Michael Rideout and the United States of America. Okay? The term Attorney General means the office of the Attorney General for the United States. Award means interim award, and final award means blah, blah, blah. Okay? Carl Thomas. Now, this person right here is the person who got in touch with me, Demetrius Hawkins. Okay? He's part of this particular agreement. And, oh, I'm sorry, if only you guys knew how much this stuff was for. This is all of the people associated with this private law. The term corporate beneficiaries mean, so what I'm going to do, you guys just saw the law, so I'd go and look it up. Now, we'll explain everything. The term FFA does not mean the Federal Aviation Administration. It means Federal Arbitration Act. This is how they hammered them in the head. They took them to arbitration. In their documents, they introduced an arbitration clause. The court nor the Attorney General communicated within the time period of the arbitration clause. Okay? When they did not communicate within the time frame of the arbitration clause, they sent them a notice of opportunity to cure. Okay, oh, look at that. In this act, the term United States means the United States of America, the government of the United States, the geographical. Look at that. Ain't that interesting? And this was written by Congress for these gentlemen in their private law. The agreement is a valid and binding settlement agreement between the parties in the United States that operates in the nature of a release dismissal agreement. Okay, the agreement contains an alternative dispute resolution clause that provided for arbitration as the exclusive remedy of relief for the parties and the United States. See, they introduced an arbitration clause, and it was a binding arbitration clause. Okay? The United States consented to the arbitration and the award made thereunder for the equitable relief of the parties and the United States are binding. Interesting, ain't it? Congress hereby expressly waives any defenses to the equitable relief award to the parties, beneficiaries, and the corporate beneficiaries by the arbitrator. The parties, beneficiaries, and their immediate family members and the corporate beneficiaries are entitled to relief established by the agreement and the award and the provisions of the act, notwithstanding any other laws to the contrary, provided that blah, 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 shall not be entitled to any relief or benefits established in the agreement and award of this act. I believe that Joey Brandon Kemp was the attorney. He got his attorney's fees. Okay, he already got paid. The purpose of this act is to provide effective relief for the enforcement of obligation and promises, terms, and conditions of the agreement between the parties and the United States of America. Affirmative relief. Remember, a lot of people don't ask for affirmative relief. all parties and beneficiaries that are natural persons and their immediate family that are confined in any jail, prison, penal institution, correctional institution, or any other form of official or unofficial detention under the authority of any state, territory, possession, or federal agency of the United States shall be unconditionally released from any such detention and set at liberty immediately without further delay. All pending legal actions and adjudicated cases in the United States of America and state territories in possession of the United States that act against parties, beneficiaries, their immediate family, whether criminal, civil, administrative, sounding in tort, or otherwise, are vacated and dismissed with prejudice, being void ab initio, and are of no further force or effect as of the date of this act, and retroactively applied to the date of the proceedings, initial filings of any such suit in action. Ladies and gentlemen, I am not making this up. When this was brought to my attention, I told you the attorney told them that they couldn't do this, that they couldn't bind the United States to an arbitration agreement. But they did. You want to know what they did, how they did it? Go and pull up the records. Now, here's the thing. You remember Eric Holder? Let's go and talk about Eric Holder, because it's 2016, remember? See, 2016, November 5th. Go back and look at the record and notice that Eric Holder had just resigned from office just prior to this. Hold on, let me get rid of that. And let's go back here to Administrative Procedures Act. Then I'm going to explain to you how they were able to do it. And then I'm going to explain to you my suggestions on what you should be doing. Then we're going to end the video. Okay. Eric. I just put Eric Holder resigns. See, it was never clear why Eric Holder would resign from office. Why would Eric Holder resign? President Barack Obama was still in office. He was going to be in office another 2 years. Why would Eric Holder resign as Attorney General for the United States? What could be the reason? Well, when you do the research on that particular private act, it was Eric Holder whom they sent, his post after a tumultuous tenure marked by civil rights advances. Tumultuous? What was tumultuous about it? See, he was the first black U.S. Attorney General. Now look, just 40 days before the midterm election shows how blah, 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 Obama is about losing control of the Senate. Oh, Jittery. Oh, I thought they were talking about that's the name of one of his children. Yeah, this is Jittery. Yeah, this is my wife, Hillary, and this is Jittery. And, anyway. After 6 years, Eric Holder retires. Why? Now, this one's 5.5 years of leading the Justice Department. Eric Holder will announce his resignation. Why would he resign? Why would Eric Holder resign? Because, and I'm going to explain this so that you guys get that, a group of men in a prison figured out how to use the administrative laws to their benefit. They wrote Eric Holder, gave him more than, now I need you guys to hold on. I'm going to have to put y'all on pause. As I mentioned, they wrote more than 500 points of averment, but they did it in a proof of claim. Remember, failure to state a claim by which relief might be granted? So they did proof of claim, but this is not their proof of claim. This is me amending it. Now, they did use this as one of their proof of claim, but I added a bunch of other stuff. Now, this is only 14 pages because I'm now using this very same process. Now, I'm not going to explain the whole process to you because I gave it to SATCOM. So we're testing it out with 2 people at this moment regarding mortgages. But, however, we're going to give you your solution to everything in just a moment. Proof of claim to the Legislative Reference Bureau, created by the Act of April 27, 1909, Public Law 208, and reorganized by the Act of May 7, 1923, Public Law 158. as a legislative agency with the primary function to draft and pass upon legislative bills and resolution for introduction to the General Assembly and to prepare for adoption by the General Assembly codes by topic of the existing general statute for which it was handed over statutory authority in 1974 to publish an official publication of the United States Code, is not operating, functioning as an non-constitutional legislative entity. Is not operating and functioning as a foreign corporate entity representing the source of authority for the existence of statutes, laws, known as the United States Code in the capacity of an administrative law agency administering the corporate affairs and public of that which created the statute. Ladies and gentlemen, basically what they're saying, proof of claim that this is not a fact, this is not true, this is not the law. So what I did is I decided to add my own stuff after I added that. Please note that although the United States Treasury Department, who prints the so-called Federal Reserve notes, these notes have no value and no backing by anything, and I put that in there. So the proof of claim is proof of claim that the original lender did not. Oh, that says land. It's supposed to be lend. We'll take care of that. Bookkeeping entry credit in the form of a loan, and failed to provide such notification and clear, unambiguous, conspicuous language terminology that any reasonable man or woman would understand, intentionally created fraud in the factum and withheld from the plaintiff vital information concerning said debt and all of the matrix involved in the making of such loan. Equifirst, when making the loan, violated Regulation Z, blah, blah, blah. Proof of claim that the banking holiday proclaimed by President Roosevelt, the Proclamation 2039, prohibited any during the course of such emergency to include but not be limited to deposits, credits, receipts, withdrawal within and between banking institutions, has suspended, declared over, abolished, repealed, has been suspended, declared over, been abolished, or repealed. In other words, proof of claim that this law no longer exists, that what President Roosevelt did is not the case at present. So they did proof of claims. They asked questions using the law and the wording of the law to say these are the facts. So if these are the facts, then you don't have the authority to do this or that. Now, they did 513, many of them being very reasonable proof of claim. Proof of claim that the government loan debt represented by this account is not secured by mortgage insurance, and that the holder in due course is the beneficiary of the mortgage insurance, that the mortgage insurance is in place should the borrower default. We only put forth proof of claim questions that we know we've already answered our own question by our proof of claim question, which while we're asking them to show cause to the contrary. See, these are our proofs of claim, and when we put our proof of claim before them, they have no other choice. So they can't respond. Why? Because they would have to contradict the facts. They would have to contradict law. We get to use that against them. They don't respond, we give them an opportunity to cure. They don't respond, then we send them a notice of default and notice of intent. So we let them know you are in default, no longer opportunity to cure. You're in default, here's what we're going to do. We're going to collect ours. Got to get yours, I got to get mine. Hold on, y'all. Give me one more second. Then we add our little caveat. Please understand that while the undersigned wishes, wants, desires to resolve this matter as promptly as possible, the undersigned can only do so upon the respondent's official response to this conditional acceptance for value and counteroffer claim for proof of claim by respondents providing the undersigned with the requested and necessary proof of claim raised here and above. Therefore, as the undersigned is not a signatory, nor a party to your social compact known as the Constitution Charter of the United States, nor notice nor cognizant of any agreement, contract between the United States and the undersigned, specifically any obtained through full disclosure, blah, 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 We added that. Does everybody else need to add this same stuff? You can just pause the video so that you can type it all up. Just hit pause, okay? Because I'm not going to sit up here and read everything, okay? By the way, let's let you read this. We create a special number for each of our documents, okay? This says this number, and it's copywritten, is secured, reserved with all rights retained. Private property, no trespass permitted or allowed under common law restrictions and prohibitions. Okay, the reason why we create that number, because that becomes our assignment number. It has to be at least 16 digits long. The undersigned herein and hereby provides the respondents 10 calendar days to commence the day of receipt of this conditional acceptance for value and counterclaim, counteroffer, proof of claim, in which to gather and provide the undersigned with the requested and necessary proof of claim raised herein and above, with the instructions to transmit said proof of claim to the undersigned and the below named notary third party for the sole purpose of certifying response and want thereof of the respondents. Further, so you do it through notary presentment. Okay, ladies and gentlemen. All right, that being the case, after you do it through notary presentment, you give them, hey, if you fail to respond or otherwise refuse to provide the requested or necessary proof of claim here and above, or you provide us with any so-called non-response by responding but not really responding specifically, blah, 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 then this is the consequence. Okay, now that I've shown you this, this is not the video where I'm showing you the process. It's a video I'm showing you where the process is recognized. What do you mean the process is recognized? Well, see, initially I said to guys, you guys, you can't do that. You can't force the United States into arbitration. Turns out they can. Interesting, ain't it? So when they did it to Eric Holder and they didn't show up, they paid for the arbitrator. And the issue was only one issue, ladies and gentlemen, whether or not they received notice of the contract, which was the proof of claim. That's the contract, saying that if they did not agree, that they would be subject to binding arbitration. If they did not respond, they didn't respond, so they became part of the agreement. By them not responding, they acquiesced to the contract. They chose not to respond. By not responding, they agreed to the terms of binding arbitration. So they found the arbitrator. The arbitrator scheduled the hearing date. Eric Holder nor any of his representatives showed up to the arbitration date. The arbitrator had no other choice but to issue a default ruling, which they could then take to the court and get the arbitrator's determination certified, which they did. In the meantime, they hired an attorney, the very same attorney I told you about, who said, no, you can't do this, and came back 3 weeks later saying, guys, I think you're onto something here. I think I might have something for you. And he's the one who produced this bill to Senator Rand Paul, okay? And he is the one who introduced the bill to the House and the Senate. The bill was passed initially, sent to Barack Obama, who vetoed it. It went back before Congress. Congress then passed the bill with a unanimous decision of majority, sent it back to the president, who then signed the bill into law. However, they put a rider on the bill saying that it was up for review 6 months later. 6 months later, in 2000 and, well, whenever, came in office, Trump came in office, Trump then refused to assign the bill again because it had an amendment attached to it. The amendment was vetoed. Congress never heard the bill again. But as I told everybody, we're not concerned with whether or not Congress heard the bill again, whether or not they accepted the bill. What we're concerned about is Congress and the President of the United States acknowledge the process, as a legal process. So because they did try to come after the people, they tried to come after the arbitrator, they tried to come after the guys who did this for trying to defraud the United States. It was the Attorney General office trying to retaliate. Sorry, you can't retaliate, you ignorant mother, because Congress has just said they recognize this as a legal process, and so did the executive branch of government. So you've been outvoted by 2/3 of the government. They had to dismiss each of the cases, including the judge getting on the record saying that this is preposterous. Then they sealed the cases that they tried to bring against these guys to the point where they won't even release the records. Okay? So what I am now showing you, ladies and gentlemen, this bill that was passed by Congress is what I am going to suggest you get a certified copy of. Okay? I'm going to suggest you get a certified copy of this bill. Why? Because this is your proof that you can take these mother to arbitration. And I would suggest going through arbitration. But look, some of you are going to be stupid. That's right, I said it. I ain't got no time to be playing no word games with you mother. Look, some of you are going to be stupid. Some of you are going to go out there and you're going to be writing all of this junk, all of this stuff that ain't got nothing to do with nothing. You're going to be making all these statements that ain't got nothing to do with nothing. There are only 3 statements that are most important when you're dealing with whether or not they had the right to arrest you, whether or not they had the right to incarcerate you, whether or not you had full knowledge of the contract, whether or not the Trading with the Enemies Act is a constitutional act and can be applied to the people of the state. And if you are declared to be an enemy combatant, this is separate. This is not part of what you're bringing up. But if you're declared to be an enemy combatant, you have the right to a due process hearing. So if you have the right to a due process hearing, when was your hearing given to you? Okay? And then you bring up all of the other facts you know about money. Now remember, the banks can issue credit. That's currency in the United States. Credit is currency. We just did an article with the... what is that thing called? SATCOM news article that will be up later this weekend that highlights the fact that credit is currency. And we show the laws to prove that credit is currency. So the banks can lend currency as long as it's been accepted by the Treasury, who has been given authorization by the president under the Act of the Proclamation 2039. The president gave the Secretary of the Treasury the right to regulate currency. So the Treasury does book entry currency. So it is currency. I just showed that to you guys on the last video. So you bring up the facts, only the facts. So go back over the common law lawsuit. Those of you, we did the video on a common law lawsuit. So just go and type in the word common law lawsuit. As a matter of fact, let's show it to you so that you'll know. I'm going to suggest people say, well, I've gone to SATCOM and shut up. I'll talk about how they used the search thing and it didn't work. And I go and use it right after that and everything is okay. We're going to do COMMONLAWSUIT. Okay. Let's do PDF. PDF. Okay, let me stop screaming at y'all. No, we don't want procedure. We don't want none of that. Oh, God, no, we don't want none of that. I'm looking for the document I put online. I guess it ain't had that many hits. Okay, so I apologize, y'all, that you can't do it this way, so I'm going to show you the other way you do it, because I told you it's at SATCOM. Okay, watch this. Watch this. No, that's common law trust. Nobody asked you about a trust. Or did I put it? Yeah, it is up there because I remember looking for it. I just said I looked for it. Okay. Uh-oh. Can't do it that way either. You guys just going to have to go to SATCOM PDF. Oh, no, we can't do PDF. We have to do this. Copy. Get rid of that. get rid of that. Get rid of that. Go there. Okay. Download section. Hey! All I had to do is just click on the download section, but oh well, downloads. That's where we want to go anyway. And I like honesty, integrity, reliability, and quality. That's high IQ. Ladies and gentlemen, we've been getting a lot of complaints about that's taking so long. And we understand. The reason why things are taking so long is because we're trying to create something out of nothing. In order for us to do that and to have it have actual value and worth, it takes time. So we are taking, individuals have paid at the most $980, and we are taking what they have paid and adding value to that. Hundreds of thousands of dollars of value. Some of them will eventually have millions of dollars worth of value. And that you don't do overnight. But people, well, I gotta pay my bills, and I gotta pay my mother, and I gotta pay my grandfather, and you know my grandfather, he ain't got much time, so he needs to get his payment soon. Okay, we don't care about that. That has nothing to do with us. That has nothing to do with reality. The unique thing about it is we have not done anything because you're not paying for that when you pay for the SAT pack. The adding value to your SAT pack, making it worth something. And no, well, I signed up for SATCOM because y'all said y'all gonna make me free. Ladies and gentlemen, nobody ever promised that any of the SAT packs of the process was to set you free. And the fact that there are people out there who are constantly telling us that, when am I going to be free? Is this going to take away from me being a citizen of America? And this going to stop me from being oh, God. You guys have no idea how much stress you're causing me. And I just want to strangle somebody. I swear I do declare. Sorry, I got to wait for the site. Oh, it still hasn't even pulled up. That's because I'm tethering, and it's a lot of documents on this part of the site. So let's do that. And then I'm going to have to make it smaller. There we go. It's about time. We're going to have to make this smaller so that everything fits in the scene and on the screen. You know what I'm saying? 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 Come on, computer. Y'all got to wait just like me. I don't want to be up there. I want to be down here. Ladies and gentlemen, when you go to SATCOM, we don't collect information as an organization on any of you. It's not our job. We don't care about your information. Now, if you're one of our members, no, we don't share your information with nobody. That's why we immediately accept it through our Nevis organization. Anybody wants that information, then they will subpoena it through the Nevis Corporation, through the Nevis Islands, which they'll have a lot of jurisdictional issues. So it is my hope that they understand. I'm going to have to wait. But ladies and gentlemen, your proof of claims, just go to this site and pull up common law lawsuit. I can't see the box to type in. There is a box here. Where's the box at? Gotta wait for that hourglass thing to stop doing hourglassing. But you use those points. Let those be your points of averment. You know what? There is another way to do this. I'm waiting for this to pull up. I don't see the box to type in because it's just pitch black. But let's do this. That's A. That's B. See, here it is right here. Common law lawsuit. Okay? Common law lawsuit. Okay? You see the other one says common law trust. So I just clicked on it. All I did was clicked on it, y'all. I clicked on it.
well, I can't find it. It doesn't work. And I don't know how to look for it myself because, I'm on that stuff, that crack stuff. And that crack stuff, man, I'm just so addicted. I've been on this stuff for probably 100 years. And so me and crack, we go way, way, way back, me and crack.
Okay, these are the people that I'm having to deal with, and I'm just tired. So in a couple of months, we're going to be bringing on new staff at SATCOM for handling some of our other, because we've been starting other companies at the same time, LLCs. We've been doing that for a reason. But see, here's the point, ladies and gentlemen. What we have been doing to benefit our clientele, our customers. And we're going to be bringing on staff to handle those things, to help us grow and improve as an organization. But we will not be bringing anybody from YouTube. Sorry. And I don't care if you don't appreciate me saying this, but some of you people on YouTube are some of the most interesting creatures on this planet. And so we don't want you, because you come in with all these ideas and attitudes and these doing research from other people who you got research on stuff that don't make no difference to nobody about nothing. Sorry. I'm sorry. It's frustrating, y'all. Okay. We did the common law lawsuit, put the case law and everything, put the arguments together for people who need to bring a lawsuit, but we're now telling you to stay out of the courts. Take this document and add each one of these points to a proof of claim that this is not the case. Okay? Proof of claim that I don't have the right to do this. Proof of claim that this, proof of claim that that. Use these proof of claims. The points that apply to you, use that as a proof of claim. Okay? Use that as a proof of claim. Then you take that proof of claim and you put it in that format. You put the arbitration clause information in without being demanding. You give them a reasonable amount of time. You send it through notice of presentment. If they don't respond, or if they don't respond because you put a clause in there that the response has to be with specificity, directly related to the question answered, and that the document is to be taken contextually and not to be construed otherwise. And that you give them calendar days to respond, at least 14, cannot be less than that. You have 14 calendar days to respond to the aforementioned information and provide the aforementioned materials that's been requested. Your failure to respond to any of the points or proof of claims contained herein shall result in an automatic default. Okay? Just as simple. Now you get them an automatic default, and then what do you do from there? You go through the arbitration. You pay the arbitrator, which is going to cost you anywhere from $600 to $1,000. Arbitrators are not cheap, but they do provide a very unique function. As a matter of fact, if any of you want to make this into a business, then what you'll have to do is you'll have to go and get your friends to become arbitrators. Anybody with a bachelor's degree, a BA, can become an arbitrator. Okay? They're still officers of the court. You should be going through arbitration. And if you go to court and you have a traffic ticket, you tell the court, oh, I wish to go to arbitration. I elect to use my alternative administrative remedy because all the courts are administrative. So I elect to use my alternative administrative remedy to arbitration. Do your research on arbitration. Do your research on arbitration and go from there. Ladies and gentlemen, it was a promise that we were going to give you a remedy. Well, now you have your remedy. Binding arbitration. It is under the Administrative Procedures Act. That's how they could bind Eric Holder in his office. That's how they could go to Congress and get Congress to act upon law, because all they were doing was following law. They are administrative organizations. The court is an administrative organization. Please do not text me, do not email me, do not write me, do not call me, do not try to even question me to get, well, what should I do with this? What should I? I'm not here for that. I'm not here to give you advice. I do not do consults anymore. So do not bother. Many of you have been emailing, texting, trying to call, and you have been ignored. You will keep getting ignored. You will be blocked. You will be spammed. I have this thing on my phone called the 6 in the morning idiot, because some idiot called me at 6 a.m. in the morning and then hung up. So the phone numbers of all the idiots who come after him get put in the idiot file, so that their phone numbers and all their calls automatically get blocked. I don't listen to the voicemails. I don't care. It doesn't matter. Okay? You can feel however you want to feel. You can think however you want to think. I am not here to be your servant. I am not here to be your slave. I don't need you or your opinion in order for me to exist and to know who I am. I am who I am because I know who I am. Sam I am. I mean, Will I am. I mean, you know, Toucan Sam. You know, the black hat. Well, anyway, you green eggs, you know what I'm saying? All right, ladies and gentlemen, ladies and gents, we're going to ask that you have a good day. Yes, and the information, once you understand that we're under military rule, and you use those laws and you go over the beginning of this to prove that we're under military rule, and you use what Congress said to prove that we're under military rule, then you ask them, what authority do you have over me? Since I went to SATCOM and I got this letter by becoming one of their SATPAC members, I got this letter from the Department of Defense that says that I'm a private citizen. So what jurisdiction do you have over me? You're military jurisdiction. I'm a private citizen. But some of you guys didn't even know that. See, that was one of the benefits that we added without you paying for that. The only thing people paid for when they bought a SATPAC was us registering their birth certificates, along with the affidavit, providing them the protection. That's what they were paying for. The 98 series number, the CPN, all of that was extra. The letter from the DOD, extra. The taking their their affidavit, converting it to a security, and then adding value to it, you didn't pay for that. We added that to your package. That's why we didn't want anybody, if something went wrong, we didn't want to become liable. So we added it at no additional charge, meaning we don't have to give it to you because it was never promised. You never paid for that. We're doing things out of the kindness of our heart. So let us continue to be kind to those of you who are members. To those of you who wanted to stay on the fence, didn't trust us, think that we were out there to steal people's money. We've been accused of being fraudulent. We got, not everybody, maybe at least one person every 5 months uses the word fraudulent or fraud. And then we just had a guy for the second time call us fraudulent. See, we took and registered an individual's UCC. We did everybody's UCCs. Okay, we did everybody's UCC. And when we did the UCC for who all applied before a certain date. Okay, when we did their UCC at no additional charge for them, we made them the creditor. We made them the grantor. We made SATCOM the secondary creditor, meaning second in line. So the grantor, or the first positioned party, can cancel the UCC at any time they want. But we were UCCing their name in every form or fashion, backwards, forwards, in and around, for them in case they hadn't already done it. We filed it for them, gave them the location of where the record is. And you know, one individual actually got mad at us because he assumed out of ignorance that we were doing a UCC in his name and creating a security and getting the benefits from him and not crediting him and letting him know. We haven't done that with a single person. That person had a legitimate gripe because when he first came, he came with an attitude and we knew he was going to be a problem. So we decided not to accept his offer and sent him on his way. But his name still remained in our file. And so when we filled out the documents, ladies and gentlemen, we did a UCC for him. And so he got mad because he thought we were creating a security for him because he received a UCC. So we just had to simply let him know that was a mistake. And you can terminate that UCC because you are the creditor of the UCC, that nobody's created any security in your name. Ladies and gentlemen, we haven't even gotten all the QSIT numbers yet assigned. We haven't even done all the process that we're supposed to be doing. We're working on that now. We're constantly having meetings and talking about this stuff now. I'm constantly on the phone with government agencies because so many people are thinking that they can duplicate what we're doing, which is hindering all the other companies from coming in. They're now scrutinizing all of our paperwork because people are thinking that they could duplicate, which is why we are not explaining what we're doing anymore to people. We're not providing any explanation on video, any explanation on the website. We're just simply telling people we never promise to give you an explanation as to how we were accomplishing it. We are just going to accomplish it. We're going to let you know when it's been accomplished, and then we'll tell you what you can do after that. But other than that, it's not our job. You don't go into Walmart telling them, hey, excuse me, you're the baker? Okay, I just bought these piece of chocolate. Okay, I need to see how you made them. Yeah, I got the right. I bought these chocolates. I need to see how you made it. I need to see what ingredients you use because I'm gluten free. And I need to make sure these things are gluten free because I don't take your word for it. So let's go. Shut up. Let's go in the back. Security, you stay out here and you wait. If anything goes wrong, I'll call you guys on inside. Okay? See ya. No other company does that. You're not going to put us in that position. We're not here to be your slaves or your servants. We're here to provide a service, exactly what is promised. If something else comes your way and is of benefit, ladies and gentlemen, we're going to be taking and putting actual funds in an account to back up your security. Eventually, for the next group of SAT packs, we're going to be buying treasury bonds, using those to fund the security. That's right, we're going to fund your securities. The same as a bank will fund a loan, would fund a security, would fund a, what do you call that? A mortgage? We're going to be funding your securities. That will be the new SAT packs that will be coming about sometime in the middle of October. They'll be considerably more valuable, and the initiation for it would be greater than what people are paying now. The ones who came in at the beginning, we did that as an introductory. That's why we are thankful for you taking the opportunity to come in. That's why we are rewarding you with so much. Okay? That's why we're giving you the bonuses. Everything else is a bonus. Not a guaranteed bonus, but a bonus nonetheless. All right. Thank all of you for taking the time to join us this day. You said you weren't going to talk about SATCOM, but you talked about SATCOM. Ha ha. You didn't keep your word. Yes, I did keep my word because I didn't talk about SATCOM. I said we. Now, but you talked about SATCOM when you went to the website. That's right. I did that because I told you we were going to show you what your remedy was, and the remedy was on SATCOM. But we ain't talked about SATCOM. Now, see, a lot of people, that's what they've been doing. They've been trying to hold us to our word, hold me to my word, try to get technical with me. Look, ladies and gentlemen, how in the world we had somebody threaten legal action against me? Told me to govern myself accordingly. Okay. By all means, put me before any judge, put me before any attorney, and see who comes out on top. You come to my videos to learn about law, and you want to threaten me with the law? By all means, let's go and see what I do to you in a court, in arbitration. See if I'm not prepared. Out of all the people on this planet, you want to come at me with a legal threat? Every single judge, every single lawyer that has ever come at me with a legal threat has always withdrew their threat. I even had a judge told me, well, you guys heard a judge tell me if I say one more word, he will hold me in contempt. And you see me, I continue to talk. And I didn't continue to just say one word, 2 words. I continue to say an entire 10 minutes worth of words. I had a judge tell me that if I continued to help people, he was going to hold me in contempt. And I continued to help people. Told him I can practice law whenever I feel like it. To this day, I have not been held in contempt. And I'm waiting for him to hold me in contempt. I'm waiting for him to retaliate, because then I do the same thing to him that these gentlemen did to Eric Holder. And I've already told him that's exactly what I will do to him. And that promise that he was going to hold me in contempt was over 6 years ago. No, not 6 years ago. No. He said that in 2014. No, he said that in 2013. Sorry, not 2014. He said that in 2013. Because that's when they started separating me. Separate! Anyway, so I say it to you all again so that you get it. I don't have time for stupidity And there are a lot of stupid people on YouTube. There are a lot of good people on YouTube. A lot of people who are searching for answers. YouTube is not your place to go for searching. All of the gurus are gone, ladies and gentlemen. All of the knowledgeable people are gone. Yeah, there are some people out there who claim they have knowledge. But go ahead and see if they're not parroting what they're hearing on my videos or what they're hearing from older videos of the guys who were here before us. So I'm retiring from this. I'm leaving this to those guys because they're the ones who want to take advantage of you. Like I said, to this day, nobody can accuse me of taking advantage of them or trying to defraud them or taking their money. To this day, nobody can say that I have not put in the time, the hours, and the work, that I have not communicated with them. I have people that I volunteered to help for free. And then when I told them I can't help you anymore, man, before they were calling me up, asking me, how do I do this and what do I do? And they were coming up and calling me for free. Now, I don't hear from them at all. Leave message on their voicemail. They don't bother to call me back. I'm tired of being used by you okay? Just that simple.
Well, I wouldn't use you. You know I love you. I listen to all of your videos. I listen to your I listened to your first video, and then I listened to your second video, and then when you changed, I listened to that video, and then when you went to that site, I went to the lessons in that video, and I followed you all over the place, and I wrote you every single day. And look, this is not Eminem and Stan, people. This is not Stan. Those of you who know Eminem and know about Stan, probably the greatest song that man has ever written, that's where he proved that he was an artist to me, when he did Stan. Okay, this is not Stan. None of you mean anything to me. If you are not, pay attention, because some of you are not getting it, and I don't care if this offends you. That's too bad. But if you're not a servant of Jehovah, you're not my friend. And I don't give a if you think that because you serve God that that's good enough. No, my friends are those who serve Jehovah, the only true God, the one who named himself, the one who says that he is God Almighty. If you serve a Trinity, knock yourself out. Okay? But if you're not a servant of Jehovah, you can't be my friend. And so many of you want to be my friend. You cannot be my friend, because my friends are only individuals who serve Jehovah, his way, not their way. I don't care if that makes you upset. You are running out of time. And so if you're going to be upset, then you're going to sit in ignorance being upset. Okay, if you don't like Jehovah's Witnesses, that's your problem, because I didn't say anything about Jehovah's Witnesses. Although those who serve Jehovah, he refers to as his witnesses. You don't believe me? Isaiah, the 43rd chapter, verse 10, 11, and 12. The Bible in the book of Revelation, the first chapter, verse 1 through 6, it calls Jesus the first faithful and true witness. Everyone who serves Jehovah must be his witness. But you people will never get that. The fact that Jehovah prophesied that his people would be called his witnesses in these last days. They didn't choose that name. He chose that name for him. Again, Isaiah, the 43rd chapter, verse 10, 11, and 12. So I can only have friends who serve Jehovah, to whom he calls his witnesses, because he says those are his people. If you're not Jehovah's people, then whose people are you? Well, the only other person in existence who have people. That's right. Adam and Eve became his people. Everybody who doesn't serve Jehovah are said to be his people. Well, I don't want none of his people as my people. You're still my neighbors, and I got to do right by my neighbors. I got to love my neighbors. Now, here's the unique thing. A lot of people are going to try to associate SATCOM with Jehovah's Witnesses. People, SATCOM ain't got nothing to do with Jehovah's Witnesses. As a matter of fact, in the SATCOM organization, we're not even allowed to talk about religion. I implemented that policy from day one. No holiday talking, no birthday talking, not because of Jehovah's Witness, but because certain people in our day, in our present day, gets offended when you talk about birthday celebration, holiday celebration. They don't want to call it Christmas no more. They want to call it, what do you call it, season, festive season, whatever they call it. I don't care about any of that junk. But SATCOM is not affiliated with any religious organization. That's why we're not even a 501c3. We don't want to be classified or associated with any religion. No, I am not SATCOM. I'm just the founder. I'm not even a member of SATCOM. I'm just a consultant to the organization. Okay, so
just in case, because some of the ignorant folks are going to say, well, he said, well, if we're not a Jehovah's Witness, we can't be associated with him, so I'm not going to be associated with SATCOM. We don't need your business at SATCOM. We're not soliciting business. Go ahead and take a look at the site. We're not soliciting. We don't advertise. Go ahead and take a look at the site. We don't advertise. But when the time comes, we've already built it. We don't need the ignorance of those people who I'm talking about on YouTube, who want a cop attitude, who want to be stupid and tell us how to run our organization. We don't need that. And I don't need it. Like I said, the moment you get offended at something I say, then you cannot be my friend. Because see, that's what you're going to find is people do things and say things 24 hours a day that offends or pisses somebody off. I'm going to piss you off. Why? Because that's your personality, to get offended at every little thing. So I am going to piss you off without even trying. It's not my intent. It's what you allow, because that's you. All right, peace out, everyone. I got to go. Have a good day. Have a good life. Have a good night. Have a good... And, oh, sorry, one last thing. Sorry! Haha! Psych! Ladies and gentlemen, I won't be doing any more videos. When I say I'm not going to be doing any more videos, the information in this video was so important. I realized it was so important. I've had this for months, but holding on to it doesn't do me any good. So maybe I might do a video where I put it on both sites and I do the typing, you know, where I just print it up and type it and let it just type up in front of you. Okay, I got to find a program that does that. But just, you know, already have it typed up, put it in the program, and have the program just type it up and dictate it as if I'm typing it right there, and then let you just read, okay, what the information needs to be. I'm thinking about doing that. But other than that, no more voice videos, no more me talking to y'all, because, sorry, ladies and gentlemen, it's too much. Okay? I love my life. I love the energy level that I have. And so I'm going to go on and live. So y'all will just have to excuse me. Have a good day. Have a good life. Have a good night. It's been a fun ride. But I can only guarantee you for a fact that the information that I put out this day, it's going to cause me a great deal of trouble. Because it's the information that they've been telling us not to share. Like I told you, I've already had a judge threaten me that if I continue to help people, he was going to hold me in contempt. Now, mind you, he did this in 2014. I said 13, but it was 14. So he did this in 2014. And it does appear that he looks like he wants to retaliate. Oh well, life goes on. But this information right here, letting y'all know, not this information that's on the screen, that's been up there for a while. The information regarding what Congress said and how the president is operating in military capacity and has been doing so, and that you guys need to challenge that as unconstitutional in every single case they put you in. You need to challenge that the current form of government is not a constitutional form of government, and that Congress did not have the right to delegate its authority to the United States military because they did so to the president under his military capacity. And you start challenging that as unconstitutional, and you challenge that before the Supreme Courts, and you go in and you challenge the law directly, or you hire an attorney. Well, you can't hire an attorney to challenge the law directly because he operates administratively, or you do your administrative process. Now look, ladies and gentlemen, I wouldn't have advised it, but those gentlemen, that award that Congress gave them, the settlement, was for $20 billion. I'm not joking. One of them got $4 billion, the other one got $6 billion, and the other one got $10 billion. It was for $20 billion with a B, as in Baker Boy. Booyah! That billion. All right. Have a good day. Oh, that was just me highlighting that, letting you know that that's a process that those gentlemen put together, and it works. That was what I was doing. Peace out. G. H-Town.